Hi, Mike DelSignore here. I want to talk about what happens if you're charged with OUI and you're arrested by the Seekonk, Massachusetts police. So arrests brought by Seekonk police, they go to the Taunton District Court. One thing to keep in mind is Seekonk police has a video of the booking, but they don't keep it for a very long time. I've been told that it erases after 15 days, so you want to do a motion to preserve to keep that video. Now, frankly, I don't believe that it actually erases after 15 days, but that's what they say. So with Seekonk, make sure you do a motion to preserve to keep these videos. I've heard this from other departments before that the machine tapes over. Now, like I said, I don't believe that in this day and age that things really record over that fast, but you want to make sure you do file the motion to preserve, because then if they do tape over it, you'll have a remedy. So now let's get to what you should expect if you're charged with OUI and what are some of the things you should look for. Well, one of the common mistakes people make is they assume that the case can't be won because it's a breath test. And I think what happens is lawyers want to basically take people's money, plea them out, not do the work to look into how to fight a case. So with a breath test case, you have to understand sort of the science, the law behind it. And that's what I do. I've spent years attending different trainings. I've traveled all over the country. I've consulted with experts. I paid my own money to talk to an expert to learn how this machine works. So when you look into the breath test, you realize that there's a lot of inaccuracies, and that's what I can give to you. I can tell you why you can still win your case despite a breath test evidence. I file motions to exclude these and have them excluded routinely. Now, they don't always get excluded, but in a significant number of cases, the breath test will never be known in court. Next, don't be in a hurry to plead the case out. I think a lot of people want to get the case over with, feeling like they put it behind them. They don't want to have this stress in their life. But while that's certainly understandable, it's better if you can get it over with and be found not guilty. So make sure the case can't be won. Recently, I looked at a case that somebody had pled out, and I said to them, I said, geez, you probably should have fought this one. So make sure if you hire a lawyer, that they know OUI law, they understand the court, they understand how these cases are actually going to play out in trial. So Taunton District Court is a pretty good court. There's some really good judges there in OUI cases, and the jury pool is very sympathetic as well. So what I look for in an OUI case, I look for what can I sort of focus on for our defense. And there's always going to be something wrong with the case. I talked to somebody this week about their police report and they crashed. And we went to the scene and we looked at the scene, and he basically crashed into the median. So I hadn't received the report, and I told him, when I get the report, I'm looking for something that I can really focus on to make the center of the defense, because the crash can't be. The crash is bad. I can minimize it, but ultimately that's where the government's going to sort of get their points. So when I did get the report, I realized that he actually did pretty well in the field sobriety tests. His one leg stand, it said he was unsteady, and he had his foot up for 11 seconds. Now, when he read that, he thought that was terrible. When I read it, I realized, geez, when I get this officer on the stand, I got somebody with their foot up for 11 seconds, 6 inches off the ground, because there was no mention in the report that he didn't keep it the proper distance. He started the exercise on time, and he looked at his foot. All instructions on the test, the officer doesn't mention anything in the report about whether he did or didn't do any of those things. But I know from years of experience cross-examining officers that if it's not in the report, they're going to agree that it's correct. Now, the foot up 11 seconds. That's good. That's a substantial amount of time. If you're under the influence, you're not going to be able to balance on 11 seconds. But I think I can. But at trial, I probably can get more than that, because it doesn't say in the report whether he picked his foot back up. And I think, and a lot of officers will say, yeah, he picked it back up, and maybe I'll even get him to 30. So that one leg stand gives me something strong to argue. His 9-step also was pretty good. Went out 9, couple missteps, heel to toe, turned back 9. So while when you look at that, of course, the narrative says failed, didn't do this correctly. But I know from studying their training that they're taught to look for a lot more than just missing one heel to toe or 2 heel to toe steps. It means he walked a straight line, it means he started the test on time, that the turn was proper. So all these things that are not mentioned in the report are stuff that show the person's not under the influence of alcohol. So those are some of the things I look for when I review a police report, and it's some of the things you should understand about your case, that it's okay and it's normal for there to be negative parts of the case. I talked to a young lady this week. She had some alcohol in the car. She had some erratic driving and field tests that were again, pretty strong. So what are we going to do? We'll probably do a motion to suppress to see if we can get that alcohol knocked out. We'll focus on the strength of the case and diminish and minimize the weaknesses. So just understand there's a lot of different ways to look at this. If you have good driving, for example, those are some of the best cases, because good driving is something that, if you're driving fine, that's indicative that you're not under the influence. So if there's good driving, we really focus on that and make that the center of the defense. So there are different ways to sort of maneuver these cases. If you're polite, cooperative, respectful, that always helps. The booking process we look into as well, and get any video. So if you're arrested for OUI in Seekonk or anywhere else, feel free to contact me. I handle OUI cases all over Massachusetts. I've been in front of the judges in Taunton District Court many times. All of the judges there I've been in front of numerous times, and I understand how that court operates. I understand the jury pools, and I'll be able to guide you in terms of what you should do in your case, so you can make the best decision for yourself. Some people want to resolve these cases, and that's fine too, but just be informed. Make sure you have the best information available. I'm here to help you. It's never too early, too late to call. My name's Michael DelSignore. Call, text anytime, 781-686-5924.